Welcome to the Deep Dive, where we take your sources and really explore the most important knowledge within them. Today, we're tackling a really vital and sometimes, well, surprisingly tricky area of criminal law.
Hmm.
It's all about the safeguards put in place by the courts, to prevent miscarriages of justice that can happen because of witness testimony.
It's a crucial area,
See,
absolutely.
think of this as your essential guide, really, to understanding how the legal system grapples with evidence that might not be totally reliable, and the key judicial tools designed to protect fairness. And we are incredibly fortunate to have the material we're diving into today. These fantastic resources have been made available to students by the University of London.
That's right.
And we need to stress this deep dive is intended purely for educational purposes.
And this discussion is brought to you by Sinorbit Academy, Sri Lanka. We certainly wish all of you preparing for exams the very, very best of luck.
Good luck. Okay, so let's try and unpack this complex but honestly critical topic. Our source material guides us through three key aspects of this challenge. First up, the judge's power, their discretion really, to give warnings about witnesses who might be unreliable.
Right.
We'll call these Makanjuola warnings.
Yep.
Second, there are the specific directions judges give to the jury when the prosecution suggests a defendant hasn't told the truth, often called Lucas directions.
Although we should probably say Burge and Peg directions now, based on the later.
Okay, good point. Birch and Peg. And finally, and this is maybe the area historically most prone to error, eyewitness identification testimony,
Definitely.
which involves the really crucial Turnbull guidelines and also the pre-trial procedures under Code D of Pasty Act 1984.
Yes, and the fundamental principle sort of underlying all this, as the Court of Appeal pointed out in Luttrell, that's Luttrell 2004, is that a special warning is needed whenever experience or research or just plain common sense tells us there's a significant difficulty with a certain type of evidence.
A difficulty the jury might not spot on their own.
Exactly. It's about making sure the jury is fully aware of potential dangers, potential limitations that they might not otherwise appreciate, and making sure they understand the need for extra caution. These warnings, they're not just read from a script. They have to be carefully tailored to the specific facts of the case in front of them.
Right.
So our mission today is really to guide you through why these types of evidence carry risk and how judges use these specific warnings and procedures to help juries navigate those potential pitfalls, ultimately trying to prevent those awful miscarriages of justice we've seen historically.
All right, let's kick off with the first area then. Makanjuola warnings. What are these exactly, and how did the law get here? What's the backstory?
Well, to really get the current picture, you need to look back a bit. Historically, English law it placed a huge amount of weight on something called corroboration.
Corroboration, meaning independent evidence, right?
Yeah.
Something separate that backed up what the witness was saying.
Precisely. Independent evidence that supported or confirmed the witness's testimony on a really important point, a material point. And the common law, it developed these specific categories of witnesses.
Ah, yes, I remember seeing those. Complainants in sexual offenses?
Yes, and accomplices of the defendant giving evidence for the prosecution.
Right, accomplices.
And also child witnesses. For these categories, judges were legally required to warn the jury. They had to say it was dangerous to convict based only on that witness's evidence, without that independent corroborating support.
So it was mandatory, even if the judge thought the witness seemed totally believable.
Exactly. It was a hard and fast legal rule tied to the type of witness or the type of offense. The judge would give the warning dangerous to convict without corroboration. But, and this is important, they could still tell the jury they could convict if, despite that danger, they were completely sure the uncorroborated evidence was true.
Seems a bit complicated.
It was. And this complex, pretty rigid system, based on these fixed categories, well, it was effectively swept away.
Yeah.
Parliament did that, mainly in the Criminal Justice Act 1988 and the Criminal Justice and Public Order Act 1994.
Ah, okay.
The law essentially moved on from demanding specific kinds of independent corroboration for those groups.
So if those mandatory rules tied to witness categories are gone, what took their place? How does it work now?
Okay, this is where the case of Makanjuola, that's Makanjuola 1995, becomes absolutely central. The Court of Appeal basically set up a new system, and it's based on discretionary warnings.
Discretionary. So the judge decides.
Yes, instead of being required to give a warning just because the witness falls into an old category, the judge now has a wide discretion. They can give a warning whenever the specific circumstances of that particular case suggest the jury needs to be extra cautious before they rely on the unsupported testimony of any witness.
Any witness at all, not just those old categories.
Any witness. It's a big shift. From a rule-based approach tied to labels, accomplice, child, etc., to a principle-based approach. It's tied to the evidence itself and whether there's a reason, in this case, to think it might be unreliable.
That sounds, well, a lot more flexible, allows the judge to look at the actual witness in context rather than just sticking a label on them.
Exactly. That's the intention. It's meant to be more sensible, more adaptable. But Macanjuola also made a really important point. The judge shouldn't just give a warning because, say, the defense lawyer suggests the witness might be unreliable during cross-examination. That's not enough.
Okay, so mere suggestion isn't enough.
No. There has to be a proper evidential basis shown in the case itself. A real reason, arising from the evidence presented, to think that this particular witness's testimony might be unreliable, not just bare accusations.
And if the judge does decide a warning's needed,
Then it has to be carefully tailored. It needs to address the specific potential unreliability that's been identified in that specific case. The source mentions, for instance, this could apply if one defendant gives evidence that implicates their co-defendants. That might raise issues about their motive.
okay, so discretion is the general rule now. But here's something that really caught my eye, and it feels important for understanding this in practice. The source says that in certain situations, even though it's technically discretionary, a warning is virtually mandatory. Can you elaborate on those? Because that sounds like where the theory meets reality.
Yes, this is crucial. Because while the old rigid rules are gone, the Court of Appeal has given very strong guidance. There are certain types of evidence that are just seen as inherently problematic, so risky that a warning is almost always going to be necessary. A classic example is evidence of cell confessions.
Cell confessions. You mean when one prisoner claims another prisoner confessed to them?
Exactly. Often fellow inmates. They claim the defendant told them details of the crime while they were both in custody. Cases like Benedetto and Labrador, that's 2003, and Stone 2005, they really highlight the danger here. These witnesses might be, and the phrase used is, tainted by improper motive.
Tainted by improper motive, meaning they might have their own agenda.
Precisely. In plain terms, they might have ulterior motives for giving that evidence. Maybe they're hoping to get a better deal from the police or the prosecution in their own case. Maybe they want revenge. Maybe they just want attention. The potential for this kind of evidence to be unreliable, maybe even fabricated or exaggerated, is just so high.
Right.
So judges must give very careful thought to warning the jury about those risks. And in practice, a warning will very, very often be required for cell confession evidence. And perhaps even more strongly, think about an accomplice giving evidence for the prosecution.
Someone involved in the crime with the defendant.
Yes. Someone who participated in the crime alongside the defendant. When they testify for the prosecution, the Court of Appeal has said, in cases like Hunter 2002, that it will usually be necessary for the judge to give a specific caution, a warning about how the jury should approach that accomplice's evidence.
And the concern is motive again.
Absolutely. An accomplice testifying for the prosecution, well, they might be trying to downplay their own role, shift the blame onto the defendant, maybe hoping for a lighter sentence or some other benefit for cooperating.
Makes sense.
Now, just like any Macanjuola warning, there still needs to be that evidential basis for thinking the accomplice actually has this kind of self-serving purpose. That comes from Macanjuola itself. But the potential is so obvious with accomplices that the threshold is often met.
Okay, so let me see if I've got this right. The old fixed mandatory categories, child witness, sexual offense complainant, they're gone. A judge won't warn just because someone falls into that category anymore. But certain situations, especially involving witnesses who have a clear potential conflict of interest or a motive to lie, particularly these cell confessions and accomplices testifying for the prosecution, they still strongly, heavily lean towards requiring a specific caution, a Macanjuola direction tailored to that specific risk of unreliability.
That's exactly it. And the Court of Appeal, generally, they give a lot of leeway to the trial judge's decision on whether to give a discretionary warning or not. They're usually reluctant to interfere with that discretion unless the decision was just completely unreasonable. You know, what lawyers sometimes call the Wendbury sense, a decision so off the wall that no reasonable judge could have made it.
So high bar to overturn the judge's decision.
Very high. However, if the judge does decide to give a warning and advises the jury, look, you should look for evidence that supports this potentially unreliable witness, then the judge should go on to identify for the jury any specific evidence in the case that is capable of providing that support if the jury chooses to believe it. That guidance comes from cases like BMT 2000.
The source wraps this up quite neatly, I thought. It says the rigid old law, the mandatory corroboration warnings for limited groups, is gone, replaced by this wide system of discretionary warnings. The UT and it's a big but. Prosecution evidence from cell confessions, and especially from accomplices testifying for the prosecution, would almost always call for a Mockingjala direction. Why? Because of that strong potential for unreliability due to improper motive, assuming there's some evidence pointing to that motive.
Yep.
And Hindle 2021 also reminds us this discretionary warning is still used sparingly overall. It's not like it happens every time the defense challenges a witness.
That's a good summary. That's the key takeaway from Mockingjala. It's flexible. It's based on evidence of potential unreliability in any witness, not just categories. But in those high-risk situations, like tainted witnesses with possible motives, the discretion heavily points towards giving a warning. Understanding that shift from rigid rules to this principled discretion is really fundamental. Remember the key cases: Mockingjala for the principal, Benedetto and Labrador, Stone, Hunter for those high-risk examples, and B, MT for identifying supporting evidence.
Okay, moving on then. Let's tackle another specific situation where a judge might need to give a warning. This is when the prosecution suggests the defendant hasn't been telling the truth, that they've lied. We often hear these called Lucas directions.
That's right. Lucas is the name people often use. The original case that gave its name to this type of direction was indeed Lucas, 1981. That case discussed the issue in the context of those old corroboration rules we were just talking about. However, the modern law, the way it's applied now regarding this specific direction, was really clearly restated and clarified in a later Court of Appeal case, Burge and Pegg, 1996.
Burge and Pegg. Got it.
So while Lucas gave it the name, Burge and Pegg gives us the definitive framework for today. And the core questions are pretty straightforward. When exactly is this direction needed? And if it is needed, what precisely does the judge have to tell the jury?
And the source makes a really crucial point right at the start here. It says a direction isn't needed automatically just because the prosecution's case means the jury has to disbelieve the defendant's story if they're going to convict.
Right.
So just because the jury rejecting the defendant's evidence leads to a conviction, that doesn't automatically trigger a specific lies direction.
No, it doesn't.
The source actually highlights that giving a specific direction about lies in that kind of situation could just confuse things for the jury, especially if, disbelieving the defendant's version leaves no other realistic option but guilt. Cases like Heron, 1996, Middleton, 2000, and Barnett, 2002 seem to support that.
Yeah, this point about avoiding confusion, it was really well illustrated in a more recent case, Murray, 2016. In Murray, the defendant denied being in a specific place, the loading bay, where the rape was alleged to have happened. That was the absolute central issue.
Okay.
But there was CCTV evidence that directly contradicted his denial.
Yeah.
The Court of Appeal in Murray said, look, for this core denial, the thing that goes right to the heart of the prosecution's case, a standard direction on the burden of proof that the prosecution has to make you sure was perfectly adequate.
So the jury just had to decide who they believed, complainant or defendant, considering the CCTV.
Essentially, yes. Were they sure the complainant's account was true and the defendant's denial was false, looking at all the evidence? A specific Lucas direction on top of that, they felt, would have just added unnecessary layers of complexity to what was, fundamentally, a straightforward issue of credibility about presence.
Okay, that makes perfect sense. So a Lucas direction, or rather Burge and Pegg, isn't needed just because the defendant says, I didn't do it, or I wasn't there, and the prosecution says, yes, you did, and here's the proof. It seems to be more about situations where the lie itself is being presented as a separate piece of evidence, something the prosecution wants the jury to use to infer guilt. Is that right?
That's exactly the distinction. Is the prosecution saying his denial is false, therefore he must be guilty? Or are they saying he told this specific lie about something else, and the fact he told that lie helps show he's guilty of the main crime?
Okay.
The court in Murray actually looked at another alleged lie in that case, too. The defendant initially denied to the police that he had invited the complainant for a smoke. Later on, at trial, he didn't really stick to that denial.
Right.
The court pointed out, well, that wasn't a central issue in the case. And crucially, the prosecution didn't actually present that specific initial denial to the jury and say, look, because he lied about asking her for a smoke, you should infer he's guilty of the rape.
So they weren't using the lie as positive proof of the main charge.
Exactly. So again, no Lucas or Burge and Pegg direction was needed for that specific lie. The absolute key is whether the prosecution is actively asking the jury, Treat this lie as a separate, positive indicator of guilt for the crime charged.
All right, so when is a Lucas Burge and peg direction usually required then? The source mentions there are 4 situations where it might be, but it doesn't list them all out. Interestingly, it does say that just relying on an alibi defense doesn't automatically mean you need the direction.
Correct. An alibi is just a specific type of denial, essentially.
So let's focus on what the direction must include when a judge decides it is necessary. This feels like the really critical part for anyone studying this.
Right. If the judge looks at the case and decides, yes, a Lucas Burge direction is appropriate here, perhaps because the prosecution is explicitly asking the jury to infer guilt from a specific lie, then the judge has to give the jury very specific guidance. There are 3 absolutely essential parts to this direction. You really need to know these. First, the judge must tell the jury that the lie can only possibly be evidence of guilt if the jury is sure that the lie was told deliberately.
Deliberately, not just a mistake or confusion.
Exactly. It wasn't an accident, a misunderstanding. The defendant intentionally fabricated something or concealed the truth. That's step 1, deliberate lie. Second, and this is a really crucial safeguard, the judge must give a strong reminder that people sometimes lie for reasons that have absolutely nothing to do with being guilty of the crime they're actually charged with.
Okay, other reasons for lying.
Yes. The source gives some really important examples. Someone might lie to try and bolster what they genuinely believe is a true but perhaps weak-looking defense. They might lie to protect someone else, maybe a friend or family member who's innocent or involved in something much less serious. They might lie out of sheer panic or fright when the police are questioning them. Or they might lie to cover up behavior that's maybe disgraceful or embarrassing, but not actually criminal.
Like having an affair or something unrelated.
Precisely. Something they don't want revealed, but which doesn't prove they committed the crime. The judge absolutely must make it clear to the jury. Just because you think the defendant lied, it doesn't automatically follow that they must be guilty of the specific offense charged. And third, the judge must tell the jury that because a lie, even if they're sure it was a deliberate lie, is alone insufficient evidence of guilt, they must not rely solely on that lie as the basis for convicting the defendant.
So the lie itself isn't enough.
No. They have to look at the other evidence in the case. They need to see if the other evidence corroborates or supports the conclusion of guilt that the prosecution is suggesting the lie points towards.
That third point, it really echoes what we heard with Muckenjula, doesn't it? The idea of needing supporting evidence. It seems like a recurring theme. Don't jump to conclusions based on one potentially ambiguous piece of evidence, like a lie, without looking for confirmation elsewhere.
Absolutely, you've hit the nail on the head. The main aim of this direction is really to stop the jury from giving too much weight to the defendant's lies, especially when the defendant hasn't admitted lying and the prosecution is arguing they must have lied. And it also flags up those vital potential innocent explanations for why someone might lie, if the defendant has actually offered an explanation. So knowing these 3 essential components, deliberate lie, innocent reasons possible, need for other supporting evidence, is absolutely fundamental. Remember Lucas for the origin story, but Burge and Peg for the modern, definitive statement of the law. And Murray is a great example of when it's not needed, even with the central denial. And remember, Goodway 1994 also confirmed if the prosecution is trying to use lies to support other evidence, like maybe a weak identification, then a direction along these Lucas Burge lines is definitely needed.
Okay, now let's move into an area that the source rightly calls particularly hazardous, and that's eyewitness identification testimony. History, unfortunately, is just littered with tragic examples of miscarriages of justice caused by people being wrongly identified.
Absolutely.
The source even mentions the case of Adolf Beck way back in the early 1900s. His wrongful convictions were apparently a big factor in setting up the Court of Criminal Appeal in 1907. That just shows how long this has been recognized as a serious problem.
It's absolutely true.
Yeah.
This persistent, nagging problem of mistaken identification, and crucially, as you said, even honest mistaken identification by a witness who is genuinely trying to be accurate, that was a major driving force behind the Devlin Report back in 1974.
The Devlin Report.
Yes, that report came about because of some other high-profile cases in the early 70s where identification evidence turned out to be wrong. Now, not all of the Devlin Report's recommendations were put into law by Parliament, but the Court of Appeal directly tackled the issue through case law. And the result was the landmark guidelines set out in the case of Turnbull in 1977.
So Turnbull, that's the absolute cornerstone here, isn't it? These are guidelines telling judges exactly what they must do when they sum up a case that relies on identification evidence.
That's right.
And the source really stresses this point. Failing to follow these Turnbull guidelines properly is a very, very common reason for the Court of Appeal to say a conviction is unsafe and overturn it.
Precisely. So for anyone studying this, you need to know two key things about Turnbull. First, when do the guidelines apply? And second, what exactly do they require the judge to say to the jury? So when do they apply? Turnbull itself says the guidelines apply whenever the prosecution's case against the defendant depends wholly or substantially on the correctness of one or more identifications of the defendant.
Wholly or substantially. Okay.
And the defense case is that the identifying witness is mistaken. Not lying necessarily, but mistaken. That's the core trigger.
The source does mention that, in practice, judges often play it safe and give the direction even if the ID evidence is only a fairly minor part of the prosecution case. Although apparently there are rare exceptions, like in a case called Najjar 2014.
Yeah, better safe than sorry often applies here.
And it makes a really strong point. Convictions based only on identification evidence that the defense says is mistaken are very rarely upheld on appeal if a proper Turnbull warning wasn't given.
That's right.
For that to happen, the identification evidence itself would have to be of absolutely exceptional quality, something you hardly ever see. The case of Fremantle in 1995 apparently showed that. If the warning should have been given but wasn't, the appeal court asks, was the ID evidence so incredibly compelling that the jury would inevitably have convicted anyway, even if they had got the proper warning? That's a tough test for the prosecution to pass.
And crucially, the Turnbull direction is needed even if the identification isn't of a complete stranger. It applies even if it's based on recognition, where the witness knew the person or had at least seen them before the actual incident.
Really? Even if you know the person?
Yes, because you can still be mistaken about recognizing someone you think you know, especially if it happens quickly or in poor lighting or under stress. That was made clear in Shamby the Queen, 1996. And it definitely applies if the identification was based on just a fleeting glimpse. The risk of error there is obviously sky high.
And it also applies even if the defendant admits, okay, I was at the scene, but denies taking part in the crime.
Yes, if there's any possibility the witness might have mistaken the defendant for someone else who was involved. Cases like Thornton 1995 and Slater 1995 confirm that. You might mistake one person in a group for another.
Okay. And the source also notes, even if the defense strategy is to say the witness is deliberately lying, not just mistaken,
Yes.
the judge should still usually tell the jury to consider, are we sure the witness wasn't simply mistaken, even if we think they might be lying? Again, that guidance comes from Shanby the Queen, covers all bases, really.
Now, there's an important distinction the source mentions, drawing on cases like Byron 1999 and particularly Gale 1999. It's the difference between direct evidence of identification and evidence that's merely description.
Identification versus description. How does that work?
Okay, so if a witness simply describes the person they saw, maybe tall, bald, wearing a red jacket, but they don't actually pick the defendant out of a lineup or point to them in court or say, I recognize him.
They just give details that happen to fit the defendant.
Exactly. In that situation, where the evidence just points to the defendant as someone fitting the description, rather than being a positive identification of the defendant, a full Turnbull direction might not be strictly required. The reasoning, as explained in Gale, is that it's a different kind of evidence with slightly different risks compared to someone saying, that's the man. That distinction makes sense. Pointing to someone versus describing features. Okay, so let's assume the Turnbull direction is needed. What are the absolute must-dos for the judge? The source lists 4 key stages or points that are essential to remember. Yes, these 4 elements are the absolute heart of the Turnbull guidelines. You really need to know these inside out. 1. The judge must clearly tell the jury there is a special need for caution before they can safely convict the defendant based on identification evidence. That's the headline. Be careful. This is risky.
Special need for caution. Got it.
2. The judge must explain the reason why this warning is necessary. Why the caution? They should explain the possibility that a witness, even a completely honest and convincing witness, can be mistaken. And critically, this is really important. They should highlight the risk that several witnesses, who all seem very convincing and identify the same person, might all be mistaken about the same thing.
So even multiple identifications aren't automatically safe?
No. The case of Pattinson and Exley 1996 actually criticized a judge's direction because it didn't stress this danger of multiple mistaken witnesses enough. Although Mills v. the Queen 1995 did say judges have some flexibility in how they word it, as long as they get the essential warning across. 3. The judge must direct the jury to examine closely the circumstances in which the identification by the witness was originally made. This means getting the jury to really think about the quality of the initial observation.
Like, how well could they actually see?
Exactly. Turnbull itself gave a list of factors to consider. It's not exhaustive, just a guide. Things like, how long did the witness actually see the person for? Was it a quick glance or a longer look? What was the distance? What was the lighting like, broad daylight or a dark alley? Was there anything blocking their view? Had the witness ever seen the person before? If yes, how often? Under what circumstances? How much time passed between the original sighting and when they later identified the defendant, say at an ID parade? And are there any significant differences between the description the witness gave right after the event and the defendant's actual appearance?
That's a lot to consider.
It is. Now, the judge doesn't have to list absolutely every single potential weakness in every single case, but failing to point out significant weaknesses can lead to a conviction being overturned on appeal. Popat No. 2000 shows that. And the judge should also point out any strengths in the identification evidence, not just the weaknesses. Cases like Pattinson and Exley and Kadir 1998 mention that for balance. And 4, the final key element. The judge must direct the jury to consider whether the identification evidence is supported by any other evidence in the case.
Looking for that corroboration idea again.
In essence, yes. Is there anything else that points towards the identification being correct? If there is other evidence capable of providing support, if the jury believes it, the judge should identify what that evidence is. And, connecting back to our earlier discussion, the judge can tell the jury that lies told by the defendant can potentially provide support for the identification.
Ah, the Lucas Burge link.
Exactly. But only if the jury is sure the lies were deliberate and they relate specifically to the issue of identity. And if lies are being relied on in this way as support, the judge absolutely must give that Lucas Burge direction about the dangers of relying on lies. Cases like Goodway 1994 confirm that link.
This whole four-step process, it sounds incredibly thorough. It really forces the jury to slow down, think critically about the identification itself, how good was the view, and then ask, okay, is there anything else that backs this up?
That's precisely the aim. The cases of Hallam, 2012, and many others have really hammered home the real-world dangers of mistaken ID and just how critical supporting evidence can be, especially if the initial identification seems a bit shaky.
And that supporting evidence doesn't have to be slam dunk proof, does it? I think Gray 2018 showed that even things like odd coincidences, if the defendant couldn't explain them, could be considered by the jury as supportive.
That's right. In Gray, the defendant's silence when interviewed about those coincidences was even something the judge was allowed to consider when deciding if there was enough evidence overall to even let the case go to the jury in the first place.
Interesting. So circumstantial evidence can definitely play a role in bolstering an ID?
Yes. And there's one more really crucial safeguard built into the Turnbull guidelines themselves. It's about the judge's power and sometimes their duty to stop the case entirely before it even gets to the jury.
Right, withdrawing the case from the jury. When does that happen?
Okay, this is critical. If the entire prosecution case against the defendant rests solely on identification evidence that the defense contests.
So ID is the only evidence.
Yes, the only real evidence. And the judge assesses that identification evidence as being of poor quality. Maybe it was a fleeting glimpse in bad light from far away.
Okay, poor quality ID and nothing else.
And there is no other evidence in the case capable of supporting that poor identification. Then the judge has a positive duty to withdraw the case from the jury right there and then and direct them to acquit the defendant.
Wow. So the judge can just stop the trial.
Yes, it's a really powerful safeguard. It recognizes that sometimes identification evidence is simply too weak, too unreliable on its own to safely ground a conviction. The case of Daly 1994 provides strong support for this judicial duty. It's rooted in the idea that it would be inherently unfair to let a trial continue based only on such flimsy evidence.
What if the ID is poor, but the judge decides to let it go to the jury anyway?
Well, even if the identification is poor, but the judge thinks it's just about capable of belief and decides not to withdraw it, perhaps because there's some slight supporting evidence or they just reach a different conclusion on quality, they should ideally analyze the issues and explain their reasons for letting it proceed. Though simply failing to give explicit reasons isn't automatically fatal to the conviction on appeal, according to Shervington 2008.
Okay, so Turnbull is this comprehensive, structured framework. It's designed for judges to guide juries through the specific, well-documented dangers of eyewitness identification. Let's recap the key bits. Tell the jury there's a special need for caution. Explain why mistake is possible, even honest mistake, even with multiple witnesses. Direct them to examine the circumstances of the observation really closely, time, distance, light, etc. And tell them to look for any supporting evidence. And crucially, the judge has the power, and sometimes the duty, to stop the case altogether if the ID evidence is poor and stands alone. Key cases: Turnbull itself, Shand, recognition, mistaken V lying, Gale, ID versus description, Popat, pointing out weaknesses, Gray, supporting evidence, Daly, withdrawing the case, and Shervington. That covers a lot. Okay, so we've talked a lot about what happens in the courtroom with warnings like Turnbull, but the legal system also tries to get things right before the trial even starts, doesn't it? By regulating how the police actually get the identification evidence in the first place. This brings us to Code D of PACE 1984.
Yes, exactly. Code D is another really critical safeguard. It's part of the Police and Criminal Evidence Act 1984, PACE-E. Its main purpose is to lay down rules, to standardize police procedures when they're obtaining identification evidence. We're talking about things like formal identification parades or video identification procedures, VIP ear.
And the aim is to make it fair, reduce mistakes.
Precisely. To minimize the risk of the witness being influenced or suggested towards picking someone, and generally to ensure the whole process is as fair and as reliable as possible. The source points us specifically to paragraph 3 and annexes 80E of Code D. That's where you find the detailed rules for how these procedures should be conducted. And these codes get updated over time to reflect best practice and new technology.
So what's the consequence if the police don't follow the procedures set out in Code D properly, if they breach the code?
Okay, if the police mess up and fail to comply with the requirements of Code D, then the defense team can make an application to the judge. They do this under Section 78.1 of PACE-E 1984.
Section 78, what does that do?
Section 78 gives the trial judge a discretion. They can exclude evidence that the prosecution wants to use if, looking at all the circumstances in which that evidence was obtained, admitting it would have such a bad effect on the fairness of the trial that it just shouldn't be allowed in.
So a breach of Code D could lead to the ID evidence being excluded under Section 78.
It could, yes. But, and this is really important, it doesn't automatically mean the evidence will be excluded. It's not a guarantee. The absolute key question for the judge under Section 78 is always the reliability of the evidence.
Reliability.
Yes. Did the breach of Code D make the resulting identification unreliable? A serious breach, something that clearly could have influenced the witness, well, they can seriously undermine the reliability, making exclusion under Section 78 much more likely. But a minor technical breach might not have much impact on reliability. It's always case-specific. The case of Godra, that's Godra-Ranjit 2010, gives some important guidance on how courts should approach this, how they should assess the impact of Code D breaches when they're thinking about exclusion under Section 78. However, even if the judge looks at the breach and decides, okay, it wasn't ideal, but I'm not going to exclude the identification evidence under Section 78, the fact that the police didn't follow the rules might still mean the judge needs to give the jury a specific appropriate warning about it.
Ah, another warning.
Yes, and this is where the Forbes warning comes into play. It's named after the case of Forbes 2001.
Okay, hang on. So a Forbes warning is specifically for situations where the police breached Code D, but the judge decided the ID evidence could still come in. It's admitted despite the breach.
Well, exactly that.
So it's different from the Turnbull warning, because Turnbull is about the general risk of mistaken identification, whether Code D was breached or not.
Precisely. Turnbull addresses the inherent frailties of eyewitness memory and perception. Forbes addresses the potential impact of a procedural failure by the police during the pretrial identification process. The Forbes warning specifically flags up the noncompliance with Code D and tells the jury to think about what impact that failure might have had on the reliability of the identification they've heard about. It's a warning focused on the process used to get the ID.
Got it.
And the case of Lariba 2015 also gives some guidance on how judges should handle maybe less serious or more minor breaches of Code D when deciding on warnings.
The case of Byrne 2016 seems like a really good example of this in action. As I recall, in Byrne, a police officer recognized the defendant from a photo. He thought it was someone he'd seen driving a van linked to some robberies he was investigating.
That's right.
And the legal question was, should a formal ID procedure have been held under Code D? Specifically, paragraph 3.12. The Court of Appeal actually agreed that yes, on the facts of that case, a formal procedure should have been held. It would have been practicable, and it would have been a useful safeguard. So there was a breach of Code D.
But, and this is a key point for Forbes, the court in Byrne decided that this breach did not automatically mean the officer's recognition evidence had to be excluded under Section 78.
So the evidence came in.
Yes, the trial judge was right to let the jury hear the officer's recognition evidence, and the Court of Appeal in Byrne specifically noted that the trial judge had given the jury appropriate guidance on the reliability of that recognition evidence, and crucially had pointed out to them that best practice under Code D hadn't actually been followed.
That sounds exactly like a Forbes warning scenario, doesn't it? Evidence admitted despite a procedural breach, jury told about the breach and potential impact.
It fits perfectly. It really highlights that breaching Code D isn't an automatic knockout blow for the evidence. Exclusion under Section 78 is discretionary. But if the evidence comes in despite a breach, it significantly increases the chances that a specific Forbes warning will be needed, telling the jury about that non-compliance on top of the general Turnbull principles if the identification itself is disputed.
And that definition of recognized recognition we talked about earlier, knowing or having seen the person before the offense, that's relevant here too, isn't it? It applies both for triggering Turnbull and for triggering the procedures under Code D.
Yes, the definition is consistent across both contexts. Now, the source also touches on some really contemporary challenges, particularly around social media identifications. This is happening more and more. What happens if a witness sees a photo on, say, Facebook and thinks, that's the guy, before the police even get involved or manage to arrange a formal ID procedure? Does that initial viewing taint everything that comes after?
That's a really interesting question. What do the courts say?
Well, the case of LT 2019 tackled this. It held that just because a witness had viewed a social media image they thought was the perpetrator, that didn't automatically make a later formal identification procedure inadmissible. It didn't automatically taint it.
Okay.
However, the court in LT said the jury should ideally be shown the original social media material, if possible. Why? To help them properly assess the circumstances of that initial viewing. How clear was the picture? How much attention did the witness pay? And importantly, the court also said a strong warning might be needed if it turns out someone else had specifically drawn the witness's attention to that social media image and suggested, hey, isn't this the person who did it? Because that obviously massively increases the risk of suggestion and contamination of their memory.
Makes sense. And there was another case, Crampton 2020.
Yes, Crampton. That involved historic abuse allegations. In that case, social media identification evidence was actually admitted as evidence in its own right. Even though there had been a breach of Code D, the police had failed to conduct a proper VIPER procedure. That's the Video Identification Parade electronic recording.
So the social media ID itself was evidence.
Yes. The Court of Appeal upheld the trial judge's decision to admit it under Section 78, noting that the judge had given the jury appropriate directions on how to evaluate that specific evidence. It really shows the courts are grappling with these new ways that identity evidence is emerging in the digital age. They're trying to balance fairness with using potentially relevant information, even if it doesn't fit neatly into the old procedural boxes.
Okay, so let's try and tie this section together. Code D of PACE E 1984 sets out the crucial rules for police conducting identification procedures before trial. The goal is fairness and reliability, things like parades, video IDs. If the police don't follow these rules, if they breach Code D, the defense can ask the judge to exclude the evidence under Section 78(1) of PACE. Exclusion depends heavily on whether the breach affected the reliability of the ID, as discussed in Godra. It's not automatic.
Correct.
But even if the evidence isn't excluded, a specific Forbes warning is likely needed. This tells the jury about the police's non-compliance and asks them to consider its potential impact on reliability. And this is in addition to any general Turnbull warning if the identification itself is disputed.
Yep, you got it.
And we've seen how cases like Byrne illustrate that Forbes scenario, and how LT and Crampton are dealing with the newer challenges of social media identifications. #tag outro. Wow. Okay, that was a really thorough deep dive into the whole complex world of safeguards around witness testimony. We've seen how this evidence can be incredibly powerful, but also, well, dangerously prone to risks and errors.
It certainly can be.
We've covered the journey from the old, quite rigid corroboration rules to the much more flexible, but sometimes still virtually mandatory, discretion involved in Makanjola warnings. Especially for potentially unreliable witnesses like those with clear motives, sole confessions, accomplices. We've pulled apart the specific requirements of Lucas directions, or rather Burge and Peg directions, for when a defendant's lies are being used as evidence of guilt. Understanding that crucial need to think about innocent explanations and always look for supporting evidence.
Crucial points.
We spent a good chunk of time on the absolutely vital Turnbull guidelines, navigating those well-known dangers of eyewitness identification, detailing the 4 key steps judges have to take to guide juries, and also that important power the judge has to withdraw weak cases entirely.
Yes, the withdrawal power is critical.
And finally, we explored the pretrial procedures under Code D of PACE 1984, how breaches might lead to exclusion under Section 78, and the specific Forbes warnings that come into play when non-compliant evidence is admitted.
We really have seen how this whole body of law has been shaped by key cases. Luttrell sort of setting the general scene for cautionary warnings. Mike establishing that core principle of discretion. Lucas and then Burge and Peg refining how we deal with lies. Turnbull, obviously the absolute bedrock for identification evidence. And then Forbes and Godra dealing with the consequences of procedural breaches by the police. Plus all those specific illustrations from cases like Murray, Gale, Gray, Byrne, LT, and Crampton showing how these principles work out in practice.
It's a constant balancing act, isn't it?
It really is. The courts are constantly trying to balance the need to use relevant evidence.
Yeah.
You can't just discard everything with the absolute necessity, the overriding principle of preventing miscarriages of justice, all the while acknowledging the inherent frailties in human observation, memory, and testimony.
And I think understanding why all these warnings and procedures exist is just as important as knowing when they apply and exactly what they require judges to say. Thinking about that historical context, those wrongful convictions, the psychological research on memory and mistaken ID, the potential motives of certain witnesses, the different reasons someone might lie, not always out of guilt.
Absolutely.
These aren't just abstract legal rules written in a textbook. They're practical tools. They're designed to try and ensure fairness and reliability in the heat of a criminal trial, guiding juries through evidence that can be genuinely tricky to evaluate.
And this detailed look, it leads us to a really important, maybe slightly provocative question to leave you with. It's a question echoed by commentators mentioned in the source material, like Ashworth and Redmayne. Despite all these detailed warnings, these procedural safeguards like Code D, given the persistent fallibility of human memory and the new ways identification evidence keeps emerging, like through social media, do the current measures actually go far enough?
Is it enough?
Or is there still a lingering risk, perhaps, that courts sometimes place a bit too much faith in the jury's ability to accurately assess the reliability of eyewitness identification, even with all the judicial guidance they receive under Turnbull and maybe Forbes? Could we do more?
That's a really powerful thought to end on. It reminds us this is still a live area of law, constantly evolving, constantly debated. It's a fundamental challenge for any system that strives for justice. Keep thinking about these concepts, keep connecting them back to those underlying principles of fairness and the pursuit of truth in criminal trials. We really hope this deep dive has been valuable for you, and very good luck with all your studies, and especially good luck with your exams.